Representing a child in a lawsuit for injuries or for a physical assault or worse, for a sexual assault, requires not only that you wear the hat of a lawyer and litigate the case effectively and investigate the case thoroughly, but you also have to make sure that the child is insulated from any additional negative effects, additional trauma, additional anxiety. You want to ensure that they receive justice. You want to make sure that ultimately the case reaches a successful resolution. So it's a balancing act. Schools are charged with properly supervising students who are in their care. The law has a reasonable parent standard, and what that essentially means is that the school and the school personnel stand in the shoes of a parent, and they have the obligation with respect to supervision and security that a reasonable parent would have under similar circumstances. And when there's inadequate supervision, when there's negligence and a failure to properly supervise and a child is injured, or an assault between two students occurs and a child is harmed, or some kind of sexual misconduct occurs, the school may be responsible. So kids get hurt all the time at school, and not every injury at school results in a basis for a claim or a case against the City of New York. In order to bring a case and be successful with a case against the City of New York for an injury that happens at the schools, there has to be a condition in the school or adjacent to the school that is controlled by the school where there's a dangerous condition, where there's a defect that they knew about, that they should have corrected, that they should have fixed, and they didn't. Negligence arises when any property owner, including the Department of Education, including the schools, has a dangerous issue, a dangerous condition on the property, and they know about it, or in the exercise of reasonable care, they should have known about it, but they fail to fix it. Several years ago, we were able to successfully resolve a very complicated case involving a sexual assault by an older student against a younger student in a summer school run by the New York City Board of Education. The City of New York tried to have the case dismissed. We were able to show that the supervision was so lacking and that the city had failed in so many respects to guard against something like this occurring, that an assault like this was reasonably foreseeable. It can be helpful to a civil case to have a parallel criminal case for the assault, but it's not always necessary. We have cases where there's no criminal case, or the criminal case is inconclusive, where the civil case can still be brought and can still be brought successfully. In fact, it's worth noting that the standards to prove a case are quite different in the criminal realm versus the civil realm. And on the civil side of things, the standard is lower. So if you have a situation where a child is at school or at school property or in an area controlled or supervised by the school, and an injury results from a dangerous condition that the school knew about and didn't fix, or the school should have known about if they were doing what they were supposed to be doing and they still didn't fix it, then there may be a basis to bring a case and to be successful.